excluded. A Crown scientist who attended to observe Bing's work, a chap called Metzger from the Carolinas, reported a very different result. He reported a result that included Guy Paul in the result, and also, in his opinion, was a conclusive result. And much of what the Crown was doing was based, I suspect, on what Metzger claimed he had seen back in 1991, which Bing assured us he could not possibly have seen. And Bing's explanation for what Metzger had seen was Metzger knew Guy Paul's DQ alpha reading before we did these tests on the unknown Christine Jessup samples. And he saw what he wanted to see, but I can assure you it wasn't there. It turned out that Bing was right and Metzger was wrong. The results that we finally got in '95, which was a conclusive result in the opinion of all three scientists, including the Crown representative, is that in fact the DQ alpha system testing excluded Guy Paul. But there's a cautionary tale there that you should try and get DNA testing to be done blind where possible.
Right. A lot of this protocol material is in your books, and I know you won't have time to see it, but it's really well worth having a look at. Because I'm already in deep trouble for having run over, I can't offer any right of reply by distinguished counsel Hutchison and Campbell on any of these issues. But let me just say, over the next year, the energies of the case law dealing with Bill C-104 and the one-year review are going to keep this very much live issues for us. And I want to thank the distinguished experts I had with me today for their assistance, and I hope that gives you at least some insight into the new legislation. Thank you. That's good.
Yeah. If we could just take a coffee break down, maybe keep it to 10 minutes if we could. Thank you. It's my pleasure to introduce the participants in the next panel this morning who will discuss the defense of voluntary intoxication, the Supreme Court of Canada decision in Davio, and the legislative response to that decision contained in Bill C-72. The chair of the panel is His Honour Judge Jim Blacklock of the Ontario Court Provincial Division in Brampton. Before his appointment to the bench in January of 1993, Jim had been counsel in the Crown Law Office criminal for some 16 years, and at the time of his appointment was general counsel in the office. He argued some of the most difficult and complex appeals before the Ontario Court of Appeal and the Supreme Court of Canada, and among those are Morgenthaler, Turpin, Zundel, Tutton, and Waite, to name a few of them. I was fortunate to be able to work closely with Jim on a number of different appeals over the time he was at the office, and I was able to see firsthand the endless preparation and painstaking attention to detail that Jim brought to all of the appeals that he worked on. And I think it was that relentless preparation that made him one of the finest appellate counsel that the Crown Law Office has ever seen. I'm also grateful to have Marc Rosenberg on the panel. He's presently the Assistant Deputy Attorney General, Civil Law, Constitutional Law, and Policy, and for the province of Ontario. And if that sounds like a big responsibility, I think that it is. Marc was called to the bar in 1976, and for many years was partner at the firm of Greenspan, Rosenberg, and Burr, and argued countless significant appeals before the Court of Appeal and the Supreme Court of Canada, and remains one of the preeminent appellate counsel in the province. In his spare time, Marc is an editor of a variety of law reports, including the Weekly Criminal Bulletin and the Dominion Law Reports, but for our purposes, I guess most significantly, the CCCs. And if that were not enough, he also does the annotations to the Merton's Criminal Code. Marc's always been interested in legal education. He's not only the head of the criminal procedure section of the bar admission course, but is always very generous with his time for educational functions such as this one, and we're very happy to have him here today. Mike Edelson has been practicing criminal law now for some 18 years, having been called in 1977. Presently, he's a partner in the Ottawa criminal law firm of Adelman, Edelson, and Meager, and is certified as a specialist in criminal law by the Law Society. He's also been involved in a number of very significant cases, especially a number involving charter litigation, and one of them, of course, being the Supreme Court of Canada's judgment in Turpin, one of the first cases construing Section 15 and Section 11F of the Charter in a criminal law context. He's the president of the Defense Counsel Association in Ottawa, and he's another person who is committed to the idea of continuing legal education, is always very generous with his time and agreeing to participate in educational functions such as this one, and we're happy to have him as well. So I'll turn it over at this time to Jim.
Right, thanks, Ken. Our panel was asked to talk about Davio and Parliament's response to the Supreme Court of Canada's judgment. And that's what we're going to try to deal with today. Thanks to David Pacheco, we have a paper that deals with the topic that you'll find at tab F of the materials. And we've included a copy of the Bill C-72, which you'll find at tab I. And before getting really into the meat of Davio, we should maybe spend a few minutes just kind of isolating the nature of the problem that we're dealing with when we deal with intoxication as a defense in a criminal law context, and also deal with some of the law pre-Davio. One thing you should remember is what we're talking about here is a defense of voluntary intoxication. That's, in effect, the problem that the court is struggling with in Davio. So that to the extent that you're dealing with a kind of a case that involves intoxication which can be said to be involuntary, we're not really dealing with a Davio situation. And an example of that kind of intoxication is a case called Regina and King, which you'll find, I think it's in footnote 2 of Pacheco's paper. And that's a situation where, in effect, Mr. Justice Ritchie talks about this notion in the context of somebody who goes and sees a dentist and gets some kind of a drug, the effects of which they're not aware of. And to the extent that they're not aware of the intoxicating effects of the drug, in the eyes of the law, their intoxication is said to be involuntary, non-culpable, and they have a defense to subsequent criminal acts that flow out of the effects of the drug they've taken in an innocent way. So that's not what we're talking about. We're talking about people who consume substances they know to be intoxicants. We're not confined to alcohol, as were the facts in Davio. Any kind of intoxicating substance to the knowledge of the person who consumes it is foursquare in the nature of the problem we're dealing with. The second thing is the court is not dealing with intoxication which is relatively mild, in the sense of just because somebody does something that they might not ordinarily do in a sober state is not what we're talking about in Davio. The traditional response of the courts is that kind of factor goes to sentence, may mitigate, may not, but there's no fundamental problem to criminal law principles posed by that type of intoxication. The problem really comes up when you've got somebody who's intoxicated to a state where they can in effect raise a reasonable doubt that an element which would otherwise be fundamental to establishing criminal liability isn't there. And yet their act appears on its face to warrant some kind of criminal sanction. And that's the struggle that the law has to deal with in this area. Certainly prior to sort of the modern era, the common law's answer was pretty simple and straightforward, right into the 19th century. And it was simply that intoxication didn't matter. And the policy underlying the notion was essentially this, that if somebody voluntarily chooses to destroy their willpower, then they're not standing in any better position than somebody who commits a criminal act while sober. Very simple rule. That rule, though, was mitigated over the course of the 19th century in a series of cases. And finally, we get the House of Lords in Beard recognizing a general notion of a defense of voluntary intoxication that's limited to certain circumstances, and lay down, in effect, three propositions. The second two are probably the most important to us. And the English courts and the Canadian courts, for better or worse, looked at the propositions laid down in Beard and essentially drew the following conclusions: that drunkenness is a defense to the extent that it gives rise to a reasonable doubt with respect to an accused forming what was referred to as the specific intent to commit criminal offenses. On the other hand, what the courts also indicated in Beard was that drunkenness falling short of this notion did not provide a defense in law. And Beard actually talked in terms of capacity to form specific intent. Now, you can kind of ignore that for the purposes of this lecture, because what happens is, subsequent to Beard, cases in this province and in British Columbia make it clear that language of capacity isn't really what we're talking about. There's a case called McKinley in the Court of Appeal, and a case called Canute from British Columbia, that basically make it clear that what we're talking about is questions of in-fact intent. Essentially what happens is, by 1977 in Canada, the law appears to be very well settled. They've interpreted Beard as creating a classification system where some offenses are viewed as specific intent offenses that drunkenness provides an answer to. Some offenses are general intent offenses, which drunkenness is treated as no defense to. And the question is, in effect, in-fact intent. That law essentially flows out of Leary in the Supreme Court of Canada in 1977. And that clearly seemed to be, at least pre-charter, what we were dealing with. The second thing that goes hand in hand with this is a notion, again, pre-charter notion, that somebody who voluntarily becomes intoxicated cannot also rely on the defense of automatism. And support for that notion is found in a judgment called Regina and Ravel, which was a decision of Mr. Justice Martin, and the citation for it is 1979, 48 CCC 2nd, page 267. That was the judgment of the Court of Appeal. It was later affirmed by the Supreme Court of Canada. There was a dissent in Leary, written by Chief Justice Dixon, which indicated that, in fact, the notion that had grown up, the distinction between offenses of general intent and specific intent, was really quite unacceptable, was unprincipled, and didn't accord with what Chief Justice Dixon's view were fundamental principles, including the presumption of innocence. He relied, in effect, on a judgment called O'Connor out of the Australian High Court. But pre-charter, that philosophy and that approach didn't fly. It didn't make it. It wasn't the law of Canada. Post-charter, we started to get notions of a new look at principles of fundamental justice through Section 7. And the Supreme Court of Canada first came to grips with the issue post-charter in Bernard. And in Bernard, the court split in kind of a funny way. Bernard was like Davio, a case of sexual assault. And in that case, the accused, in effect, appealed, claiming he was denied his charter rights by failure to put the drunkenness defense to the jury, breach of Section 7, breach of 11D. Sexual assault being a general intent offense, the trial judge refused to put it to the jury. The accused was convicted. His appeal to the Court of Appeal was dismissed. went to the Supreme Court of Canada, in effect challenging the rule in Leary with respect to general intent offenses, him not getting his defense of drunkenness even to the jury. And the Supreme Court of Canada split to Mr. Justice McIntyre writing for himself, and Mr. Justice Betts, in effect, found no breach of either Section 7 or 11D and would have dismissed the appeal. Three of the justices, Chief Justice Dixon, Mr. Justice Lemaire, and Mr. Justice Laforêt, would have found a breach of Sections 7 and 11D. And two of the justices who concurred in the result of Mr. Justice McIntyre in terms of dismissing the appeal took a different view, and this is why the law, to some extent, the battle was won by the Crown, but to some extent the war was lost in Bernard. Madam Justice Wilson and Madam Justice Laura-Dubé took the view that the defense didn't arise essentially on the facts of that case, but nonetheless took the view that there was a potential breach of 11D in not putting, even in offenses of general intent, a defense of drunkenness to the jury. And so the head count, in effect, comes out of Bernard, where there appears to be a potential constitutional violation in the former Leary rule, 5-2, in favor of some form of constitutional violation. And so that, in effect, was the shape of the law when Davio came before the trial judge for a decision. And Marc, if I could call on you to sort of tell us how the court then dealt with the issue when it gets back to the Supreme Court of Canada.
Okay, let me, I think by now you all know the facts in Davio, so let me just very briefly sum them up. As you know, the facts were terrible, and I think a lot of what happened in the parliamentary response at the end of the day is perhaps, to a certain extent, a consequence of the case itself. The case goes back to 1989. The victim was 65 years of age. She was confined to a wheelchair. The accused was kind of a family friend, or married, I suppose, more to a friend of the victim. And he used to do some errands for her. She asked him to buy her a bottle of brandy. That proved to be a very bad choice, because the evidence was fairly clear that Davio was an extreme alcoholic. And he arrives at her home at about 6 in the evening, having already spent the day drinking. He arrives with a bottle of brandy. They each have a glass of brandy. She falls asleep. And the trial judge at least was satisfied that he then finished off the entire bottle. So that when she wakes up at about 3 o'clock in the morning, he takes her out of the wheelchair, puts her in the bed, assaults her, sexually assaults her, a terrible assault, and hence the charge. The trial judge finds that he had consumed the entire bottle, aside from the little bit that she had drunk. The accused testified. He essentially denies that he had sexually assaulted the victim, but his denial is kind of an odd one, because really his story is, after the first drink at her apartment, I don't remember anything. That his position is he blacked out, and after that he awakens at about 4 o'clock in the morning. He's naked in her bed, gets dressed, leaves, and then ultimately the charges are laid. The really critical evidence is actually not given so much by the accused as by a pharmacologist who the defense called. This was a case arising in what is the equivalent of our provincial court in Quebec. And the pharmacologist said, or testified, that based on what the accused must have drunk, that's the 6 or 8 bottles of beer that he had during the day, and then the entire bottle of brandy, his blood alcohol level would have been between 400 and 600 milligrams in 100 milliliters of blood. And the evidence was fairly clear that most people would have either been in a coma or dead as a result of that blood alcohol level, but because he was an alcoholic, extreme alcoholic, and had built up a tolerance, it didn't kill him. What it did, according to the pharmacologist, is put him in a state of disassociation. And these words now start to creep in, that he was in a blackout, a state of disassociation, like automatism or like insanity. One of the important things in this case, and something that will always haunt this issue, is that the Crown did not call any expert evidence. And so at the end of the day, all that was left was a defense saying that it was possible for a person to have drunk this amount of alcohol, have lived, and be in a state of disassociation where their mind was essentially not directing the body. And I think that, as we'll probably discuss in a little more detail later, the lack of a really good evidentiary foundation from the Crown side has really, in my view, distorted the whole issue thereafter. Just picking up on what Jim was saying, the issue then is, what do we do with Bernard? Like, what is the state of the law in this area? The trial judge was of the view that, from his reading of Bernard, that it was at worst an open question, and in fact it was his view that when you looked at the way the judges split in Bernard, it was open to him to go with the concurring judgment of Madam Justice Wilson that extreme intoxication akin to insanity or automatism was a defense to a general intent offense like sexual assault. He accepted that the distinction was still there, that there was no majority in the Supreme Court of Canada to abolish this general and specific intent distinction, but that he could now opt for this view of the law. He accepted the defense evidence, accepted the evidence of the accused, accepted the evidence of the defense expert, that the accused was in a state akin to automatism or insanity, and he acquitted the accused on the basis that he had a reasonable doubt on that issue. And I think that becomes important as well when we get further on. Quebec Court of Appeal, it goes to Crown Appeals, of course, goes to Quebec Court of Appeal. Quebec Court of Appeal says that when you look at subsequent cases, and in particular a case called Pennell, which I'll come back to in a minute, the issue is still open at the Supreme Court of Canada, and accordingly, since the Supreme Court of Canada has not itself overruled Leary, which had said that sexual assault is a general intent offense and intoxication is no defense, that's the law, so they reverse enter the conviction. So it gets to the Supreme Court of Canada, and this is where the charter issue starts to arise. Really two issues. Number one, do we get rid of this specific general intent distinction, or should we go the route in O'Connor and the route of Chief Justice Dixon and Bernard and just, let's abolish it, no one understands it, and it doesn't make any sense in principle. Assuming we keep the distinction, is extreme intoxication a defense to general intent offenses? And buried in that latter question, of course, is the charter issue. Can you now, as a result of the charter, maintain a position that an accused who apparently completely lacks the mens rea for the particular offense, can they be convicted notwithstanding that, even of something called a general intent offenses? All the judges agree that we're going to keep with the general specific intent offense, the distinction, that it's still good policy. You could quibble with that, but at least that's clear. And therefore, ordinarily, intoxication will not be a defense for general intent offenses, and that really intoxication is only going to be a defense for the specific intent offenses like theft and murder and so on. The real issue then is there going to be any kind of defense for sexual assault, the general intent offenses? Justice Sapinka writes a very strong dissent. He takes a very strong policy basis. He essentially says it's just not good policy to allow people to rely on their own voluntary intoxication. He is satisfied that there's no constitutional impediment to depriving someone of the defense. He really pins his judgment, in my view, on some comments from Justice McLaughlin in the Creighton case, which you'll remember was the one of the criminal negligence cases that came down a couple of years ago. And let me just read you one line or one sentence from that Creighton case that he relies on. He says, or Madam Justice McLaughlin says, provided an element of mental fault or moral culpability is present, and provided that it is proportionate to the seriousness and consequences of the offense charged, principles of fundamental justice are satisfied. And what Justice Sapinka says in a nutshell is someone who voluntarily gets themselves that drunk to the state where they are in a state akin to automatism, that's enough moral fault for whatever consequences may flow from that conduct. That, of course, was the dissent. The majority, Justice Corey, in a quite a wide-ranging judgment with, he is sure that the Leary rule violates Section 7, fundamental justice, and Section 11D, the presumption of innocence. And again, the issue is relatively clear. He said, can the mens rea of voluntary intoxication, in other words, someone who just starts drinking and ultimately gets themselves into this kind of state, is that sufficient mens rea for whatever would flow? He looks back at all of the fault cases that have come down to the Supreme Court of Canada, especially cases like D'Souza and Creighton, and in his view, there is some minimum level of fault that has to relate to the consequences. Objective foreseeability will suffice, but merely drinking yourself into oblivion is not sufficient fault. As well, in his view, it violates the principle that substituting one element of the offense for another. He says substituting mens rea of voluntary intoxication for the mens rea of the offense violates the presumption of innocence. The presumption of innocence requires the Crown to prove every element of the offense. You don't prove that someone engaged in sexual assault by proving that they started drinking. And as a result of that, he finds that there's a violation of Section 7 and 11D. Now again, just to come back to the point I made earlier, the record, the evidentiary record, will always haunt this case, because based on the evidence that was before the court in Davio, it would seem that someone who can drink themselves to that level of intoxication is still capable of performing certain physical acts and yet be in a state of dissociation. And I think that may turn out to be a highly problematic factual issue. So the common law violates, common law rule violates Section 7, Section 11D. Justice Corey does what I would call a back of an envelope analysis, a Section 1 analysis. It's about, one paragraph really, where he simply takes the view that there's no pressing and substantial objective here, that the Leary rule was not well tailored to address any particular objective. He just offhand says that the rule does not meet the minimum impairment test and the proportionality requirements, and it's all done in, as I say, one paragraph, that's it. And so he crafts a new common law rule, which of course is the obvious response. When you're talking about a common law rule, it's open to the court to take that common law rule which violates the charter and make a new one. And what he does is he says, just essentially takes Justice Wilson's judgment in Bernard, says extreme intoxication akin to insanity and automatism will be a defense to a general intent offense. He decides to reverse the burden of proof. He says this is like insanity, and since insanity since the reverse onus in insanity is okay, let's reverse the onus in for voluntary intoxication in this area, in the general intent area. He makes some what I would call problematic statements, and I know Mike has some views on this as well. He essentially says that, in my reading of the case, the accused must testify in order to raise the issue. He says, in my view, that the accused must adduce expert evidence in order to raise the issue. It's not good enough for the accused to come in and say, I was really drunk, I can't remember what happened, period. And I guess the last piece that's left in Davio is, and I think we should all bear that in mind, it does not touch at all the normal drunkenness defense. I mean, that is still the same. Voluntary intoxication is still a defense to specific intent offenses like theft. There's no reversal burden of proof. The burden still remains on the Crown. So really, this is this narrow area.
Okay. So, in effect, then, Marc, in a murder case, on the basis of Davio, you raise a reasonable doubt with respect to the specific intent necessary for murder. You get to manslaughter. Then the onus shifts to the defense post-Davio to raise a further defense, in effect, to manslaughter, potentially leading to a complete acquittal. Namely, they didn't have the basic intent to apply force. They were so drunk that they couldn't even do that, and they have to establish that in the balance of probabilities. And that's basically the law post-Davio.
Post-Davio,
Pre-bill.
Pre-bill 72,
All right.
C-72.
Just what's your sense, Mike, in terms of some of the fallout of the decision that Marc's talked about in terms of the requirement for the accused to testify, a requirement for an expert in every case?
We discussed this before we came in the room, and it struck me as somewhat contradictory given the situation we have, for example, in a normal 253B defense, an 08 defense, which is based on the classic evidence to the contrary situation. And all of us know as a practical matter in those situations where you're trying to convince the trial judge that your client drank to a degree that would render the reading, the BAC, below the impermissible limit at the time of the offense, namely the driving or the care and control, you almost always want to have corroborating evidence of some sort, either drinking buddies, bar bills, waitresses, barmen, that type of thing, to support the evidence to the contrary. Now, the irony of Justice Corey's analysis is that we can shift the onus of proof to the accused on a balance of probabilities because it is the accused, as he says, at page 167 of the judgment in the criminal reports, it is only the accused who can give evidence about the amount of alcohol consumed and the effects on him. Well, in Davio, remember, this is an accused who's supposed to be blotto. He's supposed to have had so much alcohol that he's either insane or he's entered an automatistic state. It's mind-boggling that we can call upon that same accused who's seeking excuse for his criminal activity to testify as to, reliably so, and in the sense that he'd be a credible witness, to establish on the balance of probabilities what he did drink and the effects it had on him. It's a very circular argument, and I see some real illogicalities to demanding that kind of standard. It seems to me that it would be available and more reasonable to ask perhaps observers in the bar, people who've been with him previously that evening, to give that kind of evidence about the amount of drinking. Davio, you'll recall, it was found inferentially by the judge that he'd finished the sherry bottle. Davio blacked out, he said, after the first drink. Now, how reliable was that evidence about the quantification of his drinking? Either he had the rest of the sherry or the victim did. By force of elimination, they arrived at the view that the accused did. So we have this sort of contradictory factual problem, it seems to me, if you ever get a case that even remotely resembles Davio. Now, Justice Corey also says on the issue of expert witnesses being called in all cases, he certainly leaves a strong message behind at page 198 of the judgment that you will need an expert witness, perhaps not necessarily on the extrapolation of the alcohol, but certainly on issues of insanity and automatism. You're probably talking about forensic psychiatrists, pharmacologists, and this sort of thing. What troubles me about that is two things. One, a previous judgment of the Supreme Court of Canada called GRAT, G-R-A-A-T, in which you'll recall the court said that ordinary citizens can give evidence about the effects of intoxication and its degree. They are in no better position than police officers who are experienced in dealing with impaired individuals or experts in talking about the degree of intoxication an individual may display at the time of the alleged commission of an offense. So it seems apparently, at least, to be in some contradiction, although not entirely, with the previous judgment of the same court, particularly the judgment of Chief Justice Dixon, as he then was, in GRAT. So there's that concern when we're dealing with the issue of expert testimony. The whole issue with respect to being in an automatistic state is also of concern to me factually, because apparently when the parliamentary committee, and if you've seen the introductory paper to the introduction of Bill C-72, they referred it to committee, and in committee they heard medical evidence and forensic evidence that led them, it seems to me, to believe that neither alcohol nor drugs can place you in such a state of intoxication that you would reach automatism or a state of insanity, or akin to insanity. So you have to be asking yourselves if factually and medically that is the situation on a person physiologically and mentally. Why do we need the legislation? Presumably all the Crown has to do is call evidence in the individual case until the Court of Appeal gives it its stamp of approval, no doubt, in some appellate decision, that you can't reach this stage of intoxication or drug-induced intoxication through automatism and insanity medically. Therefore, why do we have to interfere with fundamental criminal law principle when factually you can't attain that state of mind or physically can't attain that particular state? So I'm very troubled by a number of things that have been driven by the political reaction to Davio, which all now Section 33.1 really is. It's politics. It has nothing to do with consistent and fundamental criminal law principles, in my estimation.
Marc, you wanted to say something about that?
Well, just not on the last point, but on the question of the expert evidence. I think that GRAT and Davio are really two entirely different issues. GRAT is really talking about kind of normal intoxication, that ordinary people know what the effects of alcohol. I think that what Justice Corey is clearly saying is that once you get beyond that, you are into the realm of the expert, and that this is not a matter upon which laypersons would be able to express an opinion. So I think if a police officer were to come forward and say, you know, this guy was really, really intoxicated to the point that he, in a state of akin to automatism, the judge would have to say, you're really not qualified to give that opinion, and the defense would be bound to call expert evidence. I think that the reason that Justice Corey thinks that the accused has to testify is because it's not enough for him to say, you know, it's not just laying the foundation, how much did you drink, which, you know, as Mike says, the accused evidence on that is notoriously unreliable. But also, what is the effect? I mean, it's somebody, and somehow it's got to come from the accused, I think. It has to say, I do not remember. I blacked out, and the last thing I remember was X, and then this pharmacologist or the psychiatrist comes forward and says, and accordingly, this is what happened. Now, maybe the evidence could come from another source, like a statement from the accused that the police introduced. But I think what Justice Corey is getting at is it's got to somehow, it's only the accused who knows what's in his or her mind. But again, the language is quite loose, and it's well open to the kind of interpretation Mike's putting on it.
For what it's worth, there's an article that's about to come out in the Criminal Reports, very recently done by Don Stewart, where he surveys how many times the Davio case has come up since July and the results of those cases. He refers to 2 trial judgments in the article, which, again, for what they're worth, take the view that there's no legal requirement, no requirement in law to call an expert, although this goes pretty fundamentally to the chances of any kind of Davio defense. The two cases are a case called Watt, which is an unreported decision in the Alberta Provincial Court, May 18th, 1995, and a case called Misquatus, which is a decision of the Ontario General Division, March 30th, 1995. What about possible effects on other defenses, Mike? Things like, for example, the effect on defenses like automatism. Traditionally, those have been raise a reasonable doubt defenses. What do you do now if you get an automatism that's sort of the product of multiple factors? Physical blow, a little drunkenness, who has the burden to do what?
Well, we all remember the classic law school example of the Bleda case, where the fellow falls down, strikes his head on the sidewalk, comes up, if I recall the facts, stabs someone, and you have an external blow automatism, which has always been considered the most legitimate version. It seems to me that some have suggested that in the Corey judgment, we may now be seeing a shift in onus towards the accused to, on the balance of probabilities, establish that he was an automaton at the time of the commission of the alleged offense. Some resort should be made, of course, to the Parks case, because in Parks, which you again recall was the sleepwalking case, where the fellow, sleep driving case, I suppose, where he drove across town and armed himself and attacked his in-laws in his nightmare scenario, and was acquitted ultimately, and went to the Supreme Court of Canada, and it was upheld. They had the opportunity there, it seems to me, to address whether there should be a reversal of onus on this common law rule, and did nothing about it. So, notwithstanding the more recent comments in Davio by Corey J., it seems to me that strictly speaking, automatism which is not self-induced, and I think that's the important distinction to be made, if it's not self-induced by the imbibing of alcohol, the taking of narcotic drugs, that will still fly. Indeed, you can get other cases where we were discussing a case I had about 2 years ago, where a fellow was in a pre-diabetic state, and he was suffering from very severe drops in his blood sugar levels, and unbeknownst to him. In other words, he didn't know he was becoming diabetic. And we sent him for glucose tolerance testing, and it confirmed that when his blood sugars would drop, that his brain was basically shutting down. He was suffering from blackouts. And he was successful in defending himself on that basis. So there, the second criterion that's of importance is the lack of knowledge concerning the cause of the state. Now, the third area, which is probably far more usual than the others, is the case, for example, where someone is on a medication, which they know they are to take, and they either forget to take it or they refuse to take the medication, which you see often with people who are marginally mentally disturbed, and they go into an automatistic state as a result of not taking their medication. And it seems to me that you have there the self-induced argument, which troubles the Supreme Court of Canada, obviously. So I don't think there's a change in burden of proof on automatism, but for the cases we're dealing with arising out of the Davio situation. There are other areas where we're going to see an impact or a spin-off effect from Davio in terms of the charge to the jury, and perhaps that's the last area I should talk about. If you use robbery as an example, you of course have the two elements of that offense, namely the intent to steal and the assaultive element. So what is that jury address going to say? I pity the poor trial judge who's charging the jury, because, or judge alone who's charging himself. He's going to say, ladies and gentlemen of the jury, on the intent to steal issue, the Crown has the burden of proof beyond a reasonable doubt. You need only have a reasonable doubt, obviously, to find that there's no intent to steal. Then you're down to the element of assault. And then you reverse the charge to the jury, and you'd be saying the defense, however, has the onus to establish that drunkenness or intoxication had reached such a stage that the person was an automaton or was insane. And you have two separate onuses in the same crime, And they tell us from jury studies in the States that jurors don't really understand much of what we tell them with very simple instructions. One can only hazard a guess what they're going to do with this double-headed instruction.
Okay, we've got about 5 or 10 minutes to spend on the bill. Mike, can you tell us what changes the bill makes to the rule in Davio? And it's important to bear in mind, because what's going to happen is for the bill that came into force, I think Marc indicated, what, in the last 30 days? So it's actually in force now. But you're going to have a series of sets of rules, presumably. For offenses that occur post-Davio but pre-bill, there's going to be the Davio rules. And then for offenses that occur post the bill coming into force, we're going to have a new set of rules. And what are the new game plans going to be?
Just make three perhaps preliminary comments. What Parliament considered as a result of Davio was what appears to have been an invitation by Corey J. to examine legislative response. But the legislative response he specifically referred to was a new crime of criminal intoxication. He did not address this particular series of legislative responses that 33.1 imports into the code. So Parliament was left with a couple of legislative responses: a new crime called criminal intoxication, this response, which removes the defense effectively in general intent offenses, or a third one, which Marc, I thought, adroitly raised in our discussions, and that is creating a presumption that if you are in this state, you intend the natural consequences of your acts, as it were, but it would be a legal legislated presumption. And it seems to me that really only the latter would escape very significant charter scrutiny in the end. Now, what does the bill achieve? 33.1 achieves the following three, well, at least leaves the following three criteria available. 1, intoxication continues to negatize specific intent on the reasonable doubt standard. 2, intoxication on the Davio principle will negatize general intent if it's a state akin to automatism or insanity, but it must be established on the balance of probabilities by the accused person. Finally, intoxication is no defense if it's a general intent offense and contains as an element of it an assault or any form of interference or threat of interference with bodily integrity of another person. So in the final analysis, intoxication in reference to general intent offenses to the stage of insanity or automatism would still apply as long as there's not a bodily integrity criterion attached to the offense charge, which means, in effect, that a common assault, and this is anomalous somewhat, where the penalty in normal cases might be a fine or a week in jail, it would apply to, but break and enter into a private household where there is no incursion into the bodily integrity of the person, which carries life imprisonment, you would still have a Davio defense available. So they've taken, in my sense of it, an intellectually dishonest philosophical view that this was there, and you can see in this preamble, it's there to protect women and children. That's the dressing, the optics. We all know who practice that far more men are affected by the violence that is attracted by alcoholism, many more native men than women and children are probably ever going to be affected by alcohol. Just look at the cases and look at your files. So I think this is just part of the optics to dress this up for a constitutional attack and try and save it under Section 1.
All right. Thanks, Mike. I hate to tell you this, but I think we're out of time. How are we doing? We got 5?
5 more?
Oh, all right. All right, then we'll spend a little bit of time on the bill in terms of constitutional problems. And that's the focus of the paper you have from David Pacheco. Because if you look at that paper, the problem with the bill is that the bill itself, at least arguably, has a series of very similar constitutional problems that the common law rule had that the Supreme Court dealt with in Davio. Mike, did you want to sort of highlight any of those for us?
Sure. There are 4 attacks, and I recommend David's paper. It is essentially a blueprint for attacking the constitutionality of the bill. The 4 points, and I'll just summarize them briefly, and perhaps we can have some further discussion. One is that the bill, or the new section, provides for substituted mens rea, which is impermissible. In other words, they substitute the voluntariness that's attached to the self-induced intoxication, and they take that and substitute it for the voluntariness or volitional acts or state of mind that attach to the actus reus of a general intent offense. Secondly, it does away with the minimum constitutional mens rea requirement of objective foreseeability to the point where it's a marked departure. It deals only with the marked departure issue primarily, and abandons half of the requirement constitutionally. Thirdly, it does away with the necessity of voluntariness as an essential minimum element of mens rea. Fourthly, the principle of contemporaneity is effectively abolished by the bill in reference to these offenses, because we've always required that mens rea and actus reus be contemporaneous in the commission of a crime. David cites the example of the fellow who goes in with intent to kill his spouse, aims the gun while she's asleep to shoot her, and it jams. The next day, having abandoned his mens rea, he's driving the car and he kills her when he loses control of the vehicle. You have to have you can't convict him on the second, because you have to have the mens rea and the actus reus contemporaneous with the commission of the offense, traditionally. So in these 4 areas, he argues, very persuasively it seems to me in the paper, that the bill suffers from the same failings that the court finds in Davio. And that is going to be seems to me, the focus of attack if we ever get anyone so drunk that we can get the case back to the Supreme Court of Canada.
Marc, did you want to say anything in terms of what you might try to point out as differences that help the Crown in terms of the constitutionality of the bill?
Well, let me just make a few quick points. I think what Parliament was clearly pointing or depending on was that the judicial deference to legislation. That it's one thing to alter or strike down a common law rule. It's quite another thing where Parliament has actually thought about the issue and tried to legislate in the area, and there'll be more judicial deference to that, and that runs through all of the Section 7 cases. So I think they're banking on that. They have done quite an unusual thing. They have put in a preamble to the bill. You really virtually never see that in a criminal statute, but they put in a lengthy preamble. It's going to turn out, I think, to be a two-edged sword, because some of the things they put in the preamble may turn out to be factually incorrect, and that may hurt them in trying to defend the legislation once it gets up there. And then finally, they put out what they call an information note, which is really the federal government's Section 1 analysis, and they try to run through the justification, the minimal impairment, and the pressing and substantial objective, and they try to defend the legislation. And really the issue for the Supreme Court of Canada is going to be, will we give way on this in deference to Parliament in light of the extensive hearings they held and the thought that they gave to it. What I think is going to happen probably is the Supreme Court of Canada will uphold the legislation, at least in relation to alcohol. I think what they're going to find, and this is really going to depend on the Crown. The Crown is going to have to, if they do their job properly and lead the evidence that Michael mentioned, that was led before the Parliamentary Committee, that that there is in fact no possibility that through intoxication you can become to the state of akin to automatism or insanity without actually flipping over into the disease in the mind. Then the court may very well say, well, listen, all that Parliament has done is they've legislated a mandatory factual presumption which can stand with the Constitution. I think what's going to be more problematic are some of the drugs, the hallucinogens and so on, where I think the expert evidence is less clear as to whether or not you can get into a state akin to insanity. So that's a best guess, but David, in his paper, has really run through the whole thing, the whole Section 1 analysis. It's not only a blueprint for how to attack the legislation, he also sets up whatever arguments can be made on the other side. and that's what we'll have to deal with.
Thank you.
Thank you all for having us, and that's it. Okay.
And if our next panel could be located. There we are. The next panel focuses on what many may consider to be the most interesting and developing area of interpretation of the Charter, particularly in relation to Section 24, subsection 2. We've entitled this presentation, Derivative Evidence. Is there anything that can't be excluded? Because right now that's a very legitimate question for each of us to ask when representing persons charged with criminal offenses. The first approach of statements being ruled inadmissible may be the one that quickly comes to mind. Real evidence is another level, but perhaps most particularly evidence given viva voce by other persons, including evidence as to statements made to them by the accused. The admissibility of that evidence would normally be considered to be unchallengeable, but through a series of recent cases that our panel will discuss, there is a whole fertile ground that we might wish to plow, or as I characterize it, a growth industry. We are blessed with an outstanding panel today. Chairing our panel will be Mr. Justice Coulter Osborne, and you can eliminate the hyphen. It would make it much more desirable if I might call him Coulter Osborne, but it's actually Coulter Osborne. Mr. Justice Osborne was called to the Ontario Bar in 1959. He practiced between 1959 and 1970 with a firm of Lawhead, Sills, Osborne, Madoran, and Bean, and then was senior partner in his own firm. In 1978, he was appointed a justice of the then Supreme Court of Ontario. In March of 1990, to the Ontario Court of Appeal. I've had the pleasure of participating in some educational programming years ago with Justice Osborne and found him to be articulate, highly qualified and capable, and a very desirable addition to our panel. The next member I once introduced to a Hamilton Criminal Lawyers Association by quoting from Tina Turner, well-respected judicial authority, and that's Mr. Alan Gold. Everyone knows Alan. He's a man who needs no introduction, but I'll give him one anyway. He's a partner in the firm of Gold and First. I've known Alan since 1974. There is no place he hasn't lectured. There's no lawyer he hasn't educated. There are few who have missed opportunities to hear Alan, but the feature that I find most commendable for Alan is we recognize his brilliance both as a lawyer and as an educator. He is unstinting in making himself available virtually any place, any time, to share with us the benefit of his insight and his understanding. And the quote from Tina was, "We don't need another hero because we have Alan." And Alan was one of the counsel on Regina versus RJS, which is a case that has certain principles relevant to the developing area of derivative evidence. And we'll look forward to his comments. Alan's counterpart on the RJS was Scott Hutchison. I met Scott a few years ago in Hamilton, and I've looked up to him ever since that time. And actually, I think it may have been on a Ray Day where he came down and covered provincial offense remand court. But you got to make a living somehow. And Scott is with the Crown Law Office Criminal, with the Ministry of the Attorney General. He's been before all levels of court. He's the author of Search and Seizure Law in Canada, editor of the Criminal Appeals Law Reporter, and as I said, counsel for the Crown on RJS, and we'll welcome his comments as well.
Thanks, Jeff. We want to bring this issue of derivative evidence into a kind of focus by referring to three 1995 cases, RJS, Burlingham, and a recent unreported judgment of the Ontario Court of Appeal, which is in your material, Goldhart. In order to do so, be productive if we very briefly reviewed the factual context of the three cases. Since Alan was on RJS, as has just been noted, Perhaps he could do that, and maybe in doing so indicate, subject to your right to remain silent, if the judgment bears any resemblance to the argument that was advanced in Ottawa. We'll start with RJS and then turn to the facts of Burlingham and Goldhart, and then try and relate them in the context of the issue which is before us.
RJS, or the kid's name was actually Snow, was a fairly typical fact situation, but I had been looking for a vehicle to make this argument for some time, and finally I was referred this appeal, and two kids had broken into a school in west of Toronto. It was a pretty traditional fact situation, and there was some stolen property involved, I think. I think it was a school, it may have been a manufacturer, it doesn't matter, I don't think I ever read the facts. And they were charged separately because the Crown was going to have problems proving the case. So they were charged separately, and the Crown attempted what I call the prosecutorial cross-rough, where you charge one, call one, charge two, call two. So Snow was on trial, and the co-accused was charged, who was also charged in respect to the same matter, was sought to be the witness. And so if the kid told the truth, it would be pretty simple to prove the case. The witness's counsel objected to the witness having to testify pursuant to the subpoena on the ground that the witness being charged in respect of the very same matter, there was something wrong with this. I think defense counsel was Peter Harris, very imaginative defense counsel, and he persuaded the judge that this was right, that under the charter it was wrong to compel someone to give evidence about the very matter in which they themselves are charged. And the judge upheld the objection and excused the witness from the subpoena. The Crown essentially folded its tent. The accused, Snow, was acquitted. The Crown appealed the acquittal, and the basis of the appeal was that the judge had erred in holding that the witness did not have to testify pursuant to the subpoena because of the witness's privilege, right to remain silent, Section 7 right. And on appeal, the Court of Appeal, in a relatively brief 12-page judgment that perhaps didn't do justice to the depth of the argument, said no, there was no reason to excuse the witness. The witness has to talk. Any concerns about what might happen to the evidence are for down the road. The witness will have self-incrimination privilege, but there was no basis for excusing the witness from even opening their mouths, from even talking about it. And so then I appealed to the Supreme Court of Canada and had the minor satisfaction of at least it taking 200 pages to be told I was wrong this time, which is a substantial improvement. And as you know, and I think Scott is correct, they wrote a Byzantine series of judgments. You do have to count heads to find out the ratio, to locate the ratio. And they said a number of things. In terms of the issue of whether or not a witness has to testify, it's sort of half-empty, half-full issue. They did not say that the witness was automatically excused from testifying. On the other hand, they also did not say the witness automatically has to testify. On that issue, they said that the judge has a discretion to excuse someone who is themselves charged with the offense from testifying, and there was some disagreement about what factors the judge looked at. But we don't have to get into that. In the course of that judgment, they talked about what they called derivative evidence. And that's what we're here to discuss, to talk about today. With regard to understanding our comments, let me just give you this brief overview of the legal issues involved in Snow. Okay? And as was argued to the court, part of the problem in this area has been that, you know, like the old story about the blind men looking at the elephant. Some were at the elephant's ear and said, this is like a big sail, and some were at the tail and said, it's like a snake. The precedents dealing with self-incrimination, right to remain silent, have been like the blind people at the elephant. They've been looking at different aspects. The privilege against the right to remain silent, privilege against self-incrimination, between them are this sort of amorphous idea of not having to help the state get you into trouble, of not having to help the state create the case for you to meet. And what has happened historically is that that can crystallize in different fact situations in different ways depending on what the holder of the privilege, the owner of the creature, is concerned about. In most cases, the owner of the creature has in effect said, look, I don't mind talking about it, but I don't want what I say to come back to haunt me. So that the concern hasn't been with opening the mouth in the first place, it's with what is going to come back to haunt me for my words. And in that's why most of the cases have been talking about the privilege against self-incrimination, what I call the back end of the creature. But a few cases like Ebert and Snow were concerned with the front end of the creature, namely, I don't want to have to open my mouth in the first place. I don't have to talk to you. I'm not just concerned with my words coming back to haunt me. I don't want to have to give you the words in the first place. I want to remain silent. So that's how I viewed this sort of creature that, as I say, crystallizes out in different fact situations in slightly different forms. It's like a dumbbell joined by a bar, but the two centers of gravity are at the front end. Do I have to open my mouth in the first place? At the back end, I've opened my mouth. Will my words come back to haunt me? What use can be made of the words that have come out of my mouth on the earlier occasion? And because the argument was presented that way, the judgment, as you'll see, has a certain logic and development to meet that argument. Because given that the court said that the holder does not have an absolute right to keep their mouth closed, the court had to develop some rule why forcing someone to open their mouth is nevertheless not necessarily inconsistent with Section 7. And that's what led to this lengthy and convoluted analysis of derivative evidence. So that's just the outline, the framework.
What about Burlingham?
I think Scott was going to deal with Burlingham.
I feel I should tell him, just let it go, it's over, you lost twice, we move on.
Closure.
With Burlingham, it's been mentioned by some of the earlier panels, it's a 10B case. Burlingham is arrested in relation to one murder. He confesses to that. The police, not satisfied, decide to pursue an investigation into a second homicide, which is essentially very similar to the first one that they'd been investigating. They give Burlingham a chance to talk to counsel, but then they also make an offer of some kind of plea arrangement with him that ultimately gets withdrawn by the Crown. This whole chain of events is such that Burlingham finally makes a statement to the police about this homicide, takes them to the river where the shotgun is. It's in the bottom of the river. The next morning, he makes a statement to his girlfriend, essentially saying that he'd taken the police to the river where the gun was, and that he knew something about the homicide. At the end of all of this, when he finds out that the Crown is going to resile from the plea arrangement that he thought he'd entered into, Burlingham sums up the whole situation by saying that that's a piss-off for everyone concerned. The trial judge took a similar view, as did the Court of Appeal. The key problem being, though, not whether or not there was something wrong with the way this investigation had been conducted, but what was the effect of that in terms of the evidence that would be admissible or inadmissible. At trial, the trial judge excluded the statement that he gave, the fact that he led the police to the riverside, and his actions in pointing them to where the gun was, but he admitted the gun, he admitted the statement to the girlfriend from the next day, and the fact that the police had, and he admitted the fact that the police had discovered the gun in the river. In the BC Court of Appeal, over the dissent of Chief Justice McEachran, the majority had held that that was an appropriate approach to the case, and they weren't prepared to overturn that. In the Supreme Court of Canada, after a lengthy discussion of the events that had pissed off everyone, to quote Mr. Burlingham, the issue was, how do we deal with the question of evidence discovered after a charter breach, and how do we approach the analysis in terms of dealing with that kind of problem? Of course, we had guidance from earlier cases, Terrans and Strawn, both of which had, in fairly broad terms, indicated that just about anything discovered after a charter violation, anything that could be said to be secondary evidence, and that's the language I'll use because some of the cases have suggested that the word derivative, and indeed in RJS derivative, takes on a special meaning. So when I talk about secondary evidence, it's a broad class of evidence that includes just about anything discovered after a charter breach. When we say derivative evidence, it has a causal link back to the charter breach that's in question, and that's the way it's used in RJS, that's the way it's used in some of the other cases. When we talk about the secondary evidence in this case, though, derivative evidence being a subset of that, we have to decide what are we going to do with the weapon, what are we going to do with the fact that it was discovered, what are we going to do with what he says to his girlfriend the next morning. In approaching that issue on behalf of one of the few actual majority judgments you see out of the Supreme Court of Canada these days, Mr. Justice Iacobucci follows much of what he said in RJS in terms of what the organizing principle behind Section 24.2 is and what the organizing principle in terms of trial fairness and decisions to exclude are. He begins by looking at what the correct approach is, and that's to start with the evidence most proximate to the charter breach and move out from there. You start with the statement. Once you've excluded that, you take the next step, the thing that's next closest to the statement, the facts around the river. Then you move to the next step, the actual weapon. The next step, the statement to the girlfriend. And while everybody else had agreed up until this point that the first three should be excluded, the question then was what to do with the gun, what to do with the fact of its discovery, what to do with the statement to the girlfriend. Mr. Justice Iacobucci talks about how do you assess the impact of trial fairness issues when what you're talking about is derivative evidence or secondary evidence. And it seems to be that the position he adopts is that if the secondary evidence exists independent of the breach and the Crown can show that it would have a meaningful existence independent of the breach, and by that I mean it would have been discovered and its significance understood by the Crown independent of the breach, then that evidence will nonetheless be admissible, even though there may be a trial fairness issue engaged because it has some link back to evidence that would ordinarily be considered self-incriminatory and that would ordinarily lead, or at least be a strong factor in favor of exclusion. And as he walks through that principle in the context of this case, well, the weapon never would have been discovered by the police because it was at the bottom of the river. It was utterly inaccessible. The fact that it was discovered by the police would never have been available because obviously they never would have discovered it. The statement to the girlfriend the next day is, and this is a hint of things to come in a later case, is also not admissible because if it hadn't been taken by the police to the riverside, he would have had nothing to say to the girlfriend. And Mr. Justice Iacobucci, for the majority, accepts that all of that evidence has to be excluded because, but for the police impropriety the night before, it would not have been available to the police. If the Crown wanted to overcome that on the Burlingham analysis, it would have to lead evidence to establish that it probably would have had that evidence notwithstanding the breach. So there's flip sides of the same test. This proposition is sort of brought into stark relief if you compare Burlingham to a case called Black from a few years earlier. In Black, the facts were almost identical up to the point of the Section 24.2 analysis in relation to the weapon. In both cases, there's a 10B violation by the police. In both cases, the accused makes a statement that leads the police to a murder weapon. In both cases, the police and the state seek to use the murder weapon as evidence at the accused's trial. The critical difference is that in Burlingham, the police never would have found it but for the improper conduct. In Black, the court was confident that the place where the weapon was, the accused's house, would inevitably have been searched, and the police probably would have found it and appreciated its significance, notwithstanding the inappropriate, the unconstitutional conduct. Burlingham is important because it picks up a lot of the propositions laid out originally in RJS and applies them formally in a Section 24.2 context.
All right. Then we move to the third of the derivative evidence trilogy. That's Goldhart, and it might be noted there's a case that's going to be argued in the Supreme Court of Canada with Goldhart, I'm told, a case called Stillman, which I believe is a Nova Scotia case, which engages a constitutional right not to cry, and it is a case which could be looked at with Goldhart. Do you want to just outline the facts of both cases, and then we'll move on to relate the three cases?
Goldhart is a case that I think is going to scare the pants off of most Crowns, because what it seems to suggest is that not only are you going to lose real evidence as derivative evidence, you're going to lose witnesses who are prepared to testify simply because their discovery or desire to give evidence on behalf of the Crown can somehow be tied back to some unconstitutional step in the course of the investigation. Goldhart, along with two other individuals, had a hydroponic marijuana garden, as Mr. Justice LaBrosse describes it, in his basement. The police get a tip about the garden. They engage in some unconstitutional perimeter searches to confirm the tip. The unconstitutional perimeter search is essentially the last step in the investigation as far as they're concerned. If they hadn't gotten something on that to allow them to continue, they effectively were going to close down their follow-up on the tip. Based on the perimeter search evidence and the tip, they get a warrant. The warrant gets them into the house gets the garden, and from there they have access to real evidence they think that's going to convict these three individuals. One of the three is a fellow named Meyer. By the time Meyer is charged, as is so often the case, he has undergone a religious conversion and now feels obliged to plead guilty to the offense of cultivation because it will ease his conscience. He pleads guilty before the voir dire is held into the admissibility of this evidence. In the voir dire, the Crown fails to persuade the judge that any of this evidence is admissible because, of course, the unconstitutional perimeter search tainted the warrant. The warrant fell because it was, once you excised the perimeter search, there was nothing left, and so you had a warrantless search of a residence, so all of the hydroponic equipment in the garden is gone. The Crown, having now the recently converted Mr. Meyer available as a witness, decides to call Mr. Meyer to give evidence about the hydroponic grow operation in the basement, and on the basis of that, poor Mr. Goldhart is convicted. The question in the Court of Appeal and in the trial below was whether or not the evidence from Meyer was derivative of the unconstitutional search and seizure, and if it was, how did the Section 24.2 analysis work around that evidence?
Alan, if we start with RJS and Burlingham and try and bring them into a kind of focus, are those two cases using derivative evidence to mean the same thing, and are both cases really Section 24.2 cases?
Well, RJS has to be read very carefully. It certainly fooled me the first 37 times I read it. In order to understand RJS, can I just summarize, and Scott is going to go into this in more detail momentarily, but let's just see where we're at with 24.2, because in a nutshell, here's the problem with RJS. RJS is not a 24.2 case, but Justice Iacobucci uses 24.2 in order to obtain the relevant principles. He uses 24.2 by analogy in a way that you'll see momentarily. And so it's easy to think he's talking about 24.2, but he's not. Now, in order to understand what I mean, because RJS makes Section 7 of the Charter probably one of the most complicated charter rights now. Let me just summarize where we're at under 24.2. And let me just mention Bartle, which isn't one of the three cases, but does say some important things about 24.2. First of all, under 24.2, in terms of the connection between the charter breach and the evidence that's being measured for exclusion, you do not need a causal relationship. There just has to be some connection or nexus between the charter breach and the obtaining of the evidence that is being measured for exclusion. Secondly, the Bartle and later cases use the chain of events test. In other words, if the evidence was obtained as part of the chain of events after a charter breach, then it's fit for Section 24.2 potential exclusion. Next, strict causal connection is not required. However, the strength of the causal relationship is relevant to whether to exclude or not. And finally, remoteness is another factor relevant to exclusion or not. The more remote, the more it favors admission. The less remote, the more it favors exclusion. So those are 24.2 principles, and Scott will talk about their application in Burlingham. But here's what happens in Snow. In Snow, remember, I'm arguing that under Section 7, this person has the right, because he is charged with the same offense, to determine whether or not to open his mouth. He has the right to say to the Crown, I'm charged, I am keeping my mouth shut. That essentially was the position being argued for. The Supreme Court had decided to reject that position. So they were, in effect, saying, no, the holder of the privileges cannot unilaterally decide when to open his mouth. So their problem now was to draw a line when it is permissible to force the holder of the privilege to open his mouth. What was clear was it would violate Section 7 to just say, you talk without any protection. Clearly that would violate Section 7. Then the position of the Crown was, it doesn't violate Section 7 to say you talk plus you have Section 5 Evidence Act protection and Section 13 Charter protection. In other words, direct protection. Your own words can't be used against you. That was the Crown position. That was rejected. So what's left? Well, what's left is something between those two extreme positions. Namely, you don't have to talk at all, and you have to talk, but you get some protection beyond direct protection. So the rule was you have to talk, but you get protection directly against your direct words and derivative use protection. Evidence derived from your words. Now, here's the problem. What does that mean? What is derivative evidence? And to answer that question, Justice Iacobucci looked at the Section 24.2 cases by way of analogy. And that's why it's easy to get confused. But Snow was not a Section 24.2 case. And what Justice Iacobucci said was the following. In order to comply with Section 7 of the Charter, so what he's doing is defining the Section 7 right. He's not into 24.2. He's saying this, what Section 7 of the Charter guarantees you is this, that if you have to open your mouth because the judge won't excuse you, and as I've told you, we're not dealing with that area, so we're not discussing when a judge can excuse someone. What Section 7 says is when you have to open your mouth, even though you don't want to, when you are compelled to be a witness, to have words come out of your mouth, in order for Section 7 not to be violated, your own words can't be used against you and derivative evidence can't be used against you. And what is derivative evidence? Derivative evidence is any evidence that was in fact derived from your own words. So that the first answer the Crown could in theory make is the Crown could, on its onus, show that a piece of evidence which you're characterizing as derivative is not derivative. The Crown could show it's unrelated to the words that came out of your mouth on the compelled occasion. That's the first response. If the Crown does that, then the evidence is still admissible, subject to some exclusionary rule, because it's not within the Section 7 right. It's been cast out of the Section 7 right. But with respect to derivative evidence then, Section 7 requires that when you are compelled to testify, the words that come out of your mouth and any evidence derived therefrom cannot be used against you. Now here's what's a little bit puzzling. Two things. First of all, it would seem to me that derivative evidence as part of the Section 7 shelter, if I could call it that, would be narrower than evidence that is part of a chain of events that can be measured for a 24-2 exclusion. Yet Justice Iacobucci at page 70 seems to assume the contrary, and I have a hard time imagining that. Secondly, it is hard to imagine how Section 24-2 could be used after a Section 7 violation that involves derivative evidence. I was hard-pressed to think of examples. I can only come up with one that in fact is a variation of Goldhart. I'm compelled to testify. Snow is compelled to testify, and he testifies against the co-accused, and he mentions, and by the way, one of the things we stole, we threw away at a certain point, and the police go and they get that. And now Snow comes up to his, and now the witness comes up to his trial. Sorry, Snow was the accused at the first trial. So the witness testifies, we threw something away. And the police go and get that because of the testimony that they've heard. So now we come to the witness's trial. The witness's words, in order for Section 7 to be comported with, the witness's words at Snow's trial can't be used against him. The item he described, which the police went and got, defense counsel stands up and says to the judge, that's derivative evidence, exclude that as well. The judge says, no, I don't think it's derivative evidence. I'm going to admit that item that was found. The accused is convicted. Because of that conviction, say that supposing there's a third youth involved. The third youth says, well, look, the second guy got convicted. Therefore, you know what, I'm going to make a deal with the Crown that if the second guy wins his appeal and a new trial is ordered, I'll be a Crown witness. It goes on appeal, and the Court of Appeal says, defense counsel was right. The item that was thrown away was derivative evidence. The judge erred. Section 7 was violated by admitting it at his trial. We're going to order a new trial, okay, so that the item thrown away is not being measured under 24-2. It's part of the Section 7 right content. But on the new trial, if the witness, the third accused, now shows up as a Crown witness, applying Goldhart, it seems to me that that witness's evidence is 24-2 chain of events evidence resulting from the Section 7 violation, namely the wrongful admission of the thrown away item at the second trial. That's what's so interesting about this. This has turned Section 7 into one of the few charter rights in which a court is implicated. Because what it in fact says is Section 7, right to remain silent, means that when you're compelled to testify, your words and evidence derived therefrom cannot be used against you, so that the evidence at your own proceeding is being excluded, not under 24-2, but as part of your substantive right under Section 7. So when you read Snow, it's important to keep that straight. Justice Iacobucci is constantly referring to 24-2 for guidance as to the scope of the Section 7 derivative evidence element. But the exclusion of derivative evidence based on Snow is part of the substantive Section 7 right. You haven't reached 24-2 at all. That's as clear as I think I can possibly.
How did Mr. Snow react when you explained all this to him?
Oh, yes.
Actually, it was Mr. Snow that explained it to him.
Yeah.
All right, we go to the other end of the tunnel or the highway in Burlingham, which is a 24-2 case. Am I right, Scott?
You're absolutely right, Justice Osborne. That's clearly a 24-2 case, clearly a case where the principal focus is going to be on the analysis that we're also familiar with in Collins and all of those cases that seems to have been swallowed up by this idea of trial fairness. The reason that that's important is because that is the organizing principle for both the decision by Mr. Justice Iacobucci in RJS as well as the decision in Burlingham. And the central feature is this: whether or not the admission of the derivative evidence or the secondary evidence is going to affect the trial of the accused in the same way as the admission of the principal evidence would. And so you've got, in the RJS scenario, the court's focus is admitting this evidence going to be tantamount to compelling him to testify at his own proceedings, so that if an accused is obliged to testify at another trial, gives evidence that leads the police to real evidence they would not otherwise have had available to them or would not have appreciated the significance of, putting that evidence in at his trial later is tantamount to using his testimony against him and clearly tantamount to obliging him to participate in an unfair trial. The same proposition is what's at stake in Burlingham, because what the court is saying there is, look, putting the gun in, putting the statement to the girlfriend in, putting the fact of discovery of the gun in is tantamount to putting in the statement made by the accused to the police the night before. The only way for the Crown to get around this is to sever that link. And the way to sever it, the way to sever this continuing taint of trial unfairness is for the Crown to demonstrate that the evidence probably would have been available notwithstanding the initial unconstitutional step. So that if, for example, the Crown could say that divers routinely swim the Kootenai River and we would have found that gun eventually anyways, in that situation, the trial unfairness doesn't carry forward, because even though the actual discovery is derivative in the sense that it only happened when it happened because the accused led them to the gun itself is still admissible because it would have probably been discovered in any event. And the significance of that, again, is this notion that the Crown can sever this continuing taint of trial unfairness by demonstrating that this evidence would have been available or probably would have been available to the police or to the state, notwithstanding the unconstitutional step that had preceded it. That test, I would suggest, is the same in both the RJS and the Burlingham situation. Where it becomes really difficult, where that analysis becomes really difficult, I think, is when you get to cases like Goldhart, where what's in issue isn't whether or not you should be admitting real evidence that the police have discovered, but an independent third party who existed independent of the police and who has an independent mind of their own and is in a position to make a decision whether to testify or not, completely independent of anything that the state has done. And when you look at the divided opinion of the court in Goldhart, that, again, comes into a starker relief, because what you really have in the distinction between the majority and the minority in Goldhart, I would suggest, is completely different approaches to the issue of what it was that got Meyer, the witness for the Crown, into the box. Mr. Justice LaBrosse, on behalf of himself and Madam Justice Abella, takes the view that the investigation would have been dead but for the unconstitutional step. Anything that came after that was derivative of, in the sense that the Crown could never say that they would have gotten to it anyways. And on that basis, he's prepared to exclude that evidence. Mr. Justice Brooke takes a different view, sees a real temporal distinction between the arrest and the evidence, and proceeds on the basis that Meyer, the witness, would have been available to the Crown, probably would have been available to the Crown, because independent, discrete human actor, and that's enough of a break for the Crown to demonstrate to have that evidence available to it at that trial.
Right. Then is is the majority judgment in Goldhart a judgment that stands for the proposition that there's no difference between the viva voce evidence of what appears to be a more than willing witness and the introduction of a gun or a body fluids from an accused person?
I don't know that the test can be put quite that high. I don't think it's fair to say that Mr. Justice LaBrosse would accept that witnesses and real evidence exhibits are in the same category. What he was prepared to accept in this case was that the Crown had not only discovered this witness, it wasn't just a case of where the Crown finds the witness because of an unconstitutional step. The very evidence of the witness, the only reason, in Mr. Justice LaBrosse's view, that this witness testified was because he'd been caught out by the Crown in the course of this unconstitutional search. If it wasn't for the unconstitutional search, not only would the police not know about the identity of Meyer would not have given the evidence he did. And it's from the Crown's perspective, I would suggest that the problem is you end up with a certain line of logic that's like the old saw about for want of a nail the shoe was lost, for want of the shoe the horse was lost, for want of the horse the battle was lost. Well, at some point in there, it becomes these suggested causal links lose any significance, really, and there's other things that have to be in play. And I think that the central distinguishing factor from my perspective, at least, in Goldhart is the idea that Goldhart wouldn't have testified but for the search. And as soon as you accept that proposition, I think you're stuck with the result in Goldhart. I don't know that defense is going to be able to establish that very often, because I think the intervening human actor is always going to be a powerful argument for the Crown to be able to point to say that this person would have been available anyways.
Is there any question in Goldhart itself whether that proposition is properly founded in the evidence?
That's, I think, a key problem, because Mr. Justice Brooke takes the view that that's not really the import of the finding of the trial judge, and that he has a different view. He says that Meyer would have been available in any event, and so to a degree, there's a conflict between the majority and the minority in terms of their interpretation of the record.
Alan, in Goldhart, one of the distinguishing the features that separates the majority and the minority, apart from the fact they refer to the witness in issue by different names, is the question of reliance on American authority, American suppression of evidence cases. What's your view on that issue, and if if we aren't to rely on American authority in that area, why?
Well, I think this is one area where the American authorities aren't particularly useful, and that's because their exclusionary rule is a judge-made rule, and as a result, being judge-made, it's sort of the quality varies with the particular manufacturer from decade to decade. One of the things that's happened is their cases have become much more result-oriented. They've lost the appreciation that these rules are concerned with the rights of innocent citizens, and they much more factor in the reality that they're dealing with a criminal and reaching the result, and we were wise enough not to do that. But the other factor is that even they will exclude live witnesses, but the way they put it is that the illegality must be more closely related to the obtaining of the live witness. With regard to Goldhart, let me just point out one thing that I think has been made clear, but possibly not. The charter breach in Goldhart created the entire case. That's where I think the majority and the minority part company. What the majority was trying to say is that without the illegal search, there never would have been a case at all. It isn't the situation that the illegality affected part of a case and a witness came forth and cooperated with the Crown. There would have been no show for the witness to star in without the illegality. That's crucial, and that's what makes Goldhart perhaps an unusual situation. That's a different situation where there could well have been a case, but the witness came forward or something like that. In that case, I think the evidence would not be excluded. But please remember that about Goldhart. In Goldhart, the entire case, the sine qua non, but for causation, applied to the very existence of the prosecution itself, and that the majority makes that point several times. So as a result, if you don't exclude the witness, you are giving the police an incentive to commit illegalities, because who knows, we might be able to come up with a case in any event. And their position was the charter shouldn't have been breached. If the charter hadn't been breached, there never would have been a case at all for this person to be a witness in. And that, I think, is the single most important factor in Goldhart.
The competing view, the view of the minority in Goldhart is reflected in the United States Supreme Court case Ceccoloni, which is in tab 10 of your material, and I won't waste time going into its somewhat unusual facts. Scott, we've got about 1 minute. Would you please tell everyone where Goldhart is, where it's going, and where the companion case Stillman is and is going? Then we'll wrap it up.
Very quickly, Stillman is a case out of, I think, the New Brunswick Court of Appeal that's on its way up on the basis of a dissent. In Stillman, there was a young offender who was ultimately transferred. He's interrogated by police. That's a prophetic sound. He's interrogated by police. At the end of it, he's crying, and at the end of this interrogation, blows his nose. The statement is excluded, but the police, no fools they, pick up the, as Renee Pomerance would say, mucus-laden Kleenex, take it down to the lab, and lo and behold, it's chock full of DNA. The question is whether or not the Kleenex is, or rather the mucus on the Kleenex, is derivative of the unconstitutional interrogation. That's the issue that's gone up on the basis of a dissent. Goldhart will be heard in the Supreme Court of Canada with that case on the basis of Mr. Justice Brooks' dissent, and we'll may get some nice clean, let's hope, decision out of the Supreme Court of Canada with respect to derivative evidence.
Stay tuned for that late-breaking news, and that will conclude this part of this morning's session.
Hang on, don't go yet. We're going to take 10 minutes, if you don't mind, and Ken and I will see how quickly we can cover the 5 cases or more that we promised you. Okay, ready? Here we go. First case. It's Supreme Court of Canada decision, Regina versus Collins, Regina versus Pelfrey. And Dean was counsel at the trial level, and Mike MacArthur, who's here, was also counsel at the trial level. Stands for this proposition, which sounds rather astonishing. Is it ever possible to get a stay of proceedings for unreasonable delay on a charge of murder? And the answer is yes. And what if the delay that was really significant, directly significant, was as short as 4.5 months? And the answer is yes. And the particular circumstance in Collins and Pelfrey that the Supreme Court of Canada focused on related to aspects of the prosecutorial conduct. What you have, and it's in paragraph 10, the sequence is as follows. Feature number 1, accused in custody. Number 2, overall length of delay was approximately 22 months. Number 3, a part of the reason for the delay related to some tardiness in the Crown in making disclosure. And further, to some extent, the Crown not cooperating in getting an early date set. What happened was, defense had a significant amount of disclosure, estimated 4 days for the preliminary. They get close to that point, a whole lot of additional disclosures now given to them. Now it appears much more time is needed. Defense take the view, look, we aren't going to contest committal anyway. We're going to need more time to finish the prelim. Let's right now figure out when we're going to finish the prelim and have the trial shortly thereafter. But that didn't get to happen. But most significantly, defense said, what about when they got to the level of the trial, the Crown wanted an adjournment. Position the Crown took, well, there's a witness in the United States who is unavailable. I understand that she's ill in hospital, broken her leg or otherwise. And defense said, well, give us details. What happened? And the response the Crown gave was, well, my officer, I've sent him down there to check into it, and that's the information I have back. Result, 4.5 months delay with the accused in custody, trial doesn't get reached. And what happens first trial, directed verdict of acquittal, goes to the Court of Appeal, they send it back. Trial number 2, it now comes out the officer didn't get sent down to the States, he phoned down there. It turned out further that the woman, I think, had broken her leg or something of that sort, or was getting married. She was available. She could have been available to testify at the trial. It didn't need that kind of delay. That came up before Mr. Justice Kaverzan, so it had to do with the inadequate investigation by the Crown of the circumstances which put him in the position of having to ask for the adjournment, efforts made by the defense. I like the phrase used that there were entreaties by defense counsel which would have enabled the trial to proceed on schedule. But they basically drop it at the feet of the Crown, accused in custody, 4.5-month delay. Decision by the trial judge to stay the proceedings was upheld. That's the essence of Collins and Pelfrey. One interesting passage in dissent, the Crown tried to argue, well, they could have applied for bail. Well, these guys were mugs who didn't have the capacity to get sureties or anything available. That was not held against the defense. On the issue of prejudice, because there was 4.5 months in custody, argument being, well, they could have applied for bail, that didn't wash. That was a decision counsel made at trial that the accused really didn't have the means to be able to put up any kind of bail. That wasn't held against the defense. So result, stay of proceedings due to conduct of the Crown. The case is useful in that regard, not only in terms of the offense, length of time, but circumstances.
Jeff, I just add to that. I mean, I think it's important because it shows you that if you have one shorter period of time which has a real problem with the delay, in this case it was the 4.5-month period where the accused were in custody, so you've got some serious prejudice that the accused suffered as a result of an adjournment which turns out apparently not to be necessary and which could have been, had the Crown made the appropriate inquiries, found out about. So it's that shorter, significant period of time that the court primarily relies upon to stay the proceedings.
And don't forget the efforts of the defense counsel to try and basically elicit from the Crown, what have you done in this case? There was a trial record available by the defense to have exhausted all measures to get the matter to proceed as soon as possible. That's also an important part of the case. Next one.
Okay. I just wanted to draw your attention to the judgment of the New Brunswick Court of Appeal in Leclerc. It's one of the cases that I think you've got in your materials. It's about the 6th case in. It deals with the question of automobile searches. In the United States, of course, they have a recognized exception to the warrant requirement for automobiles, and probably the high water mark there is the Ross decision in 1982, where basically the Supreme Court of the United States held that police could conduct a warrantless search of basically the entire interior plus the trunk plus any packages inside the trunk with respect to any motor vehicle, provided that the search was based on probable cause. Early cases in Ontario, Rayo and Macomber, seem to follow that basic approach in recognizing a broad exception. More recent cases, namely the IDD case from Saskatchewan and which was subsequently approved by the Supreme Court of Canada in Grant and Reilly in 1993, when it took a different approach, saying that no, we're not going to recognize a general blanket exception with respect to motor vehicles, and that it ought to be determined on a case-by-case basis, and that what the Crown needs to show where the police act without a warrant is that there's some exigent circumstances, the imminent loss, removal, destruction of evidence, which makes it not feasible to obtain a warrant. And I think that the decision of the New Brunswick Court of Appeal in Leclerc shows us how that kind of an approach is applied. Basically what happens is the accused is stopped as a result of some information that was obtained by the police. He's arrested. And they search the vehicle, they open the trunk, and they find inside some 600 cans of tobacco, which are not there in accordance with the Excise Act. So they find this huge amount of tobacco, and the issue is whether the police were entitled to conduct this warrantless search of the trunk of this automobile. And the court, relying upon the earlier cases, seems to suggest that it has to be a situation where it's simply not feasible to obtain a warrant, and those exigent circumstances did not exist in this case. There was no reason why since the accused was under arrest, why they couldn't have got it, went to a justice or a provincial court judge and obtained a warrant, and they suppressed the evidence in the result.
And what's kind of fun about that one, you tend to think, well, really, what are we doing here? How convenient or inconvenient is it for the police? Is it really an unnecessary step or necessary, or should it be a necessary step for them to get a warrant? If they have control over the vehicle and it's not an exigent circumstance case, this case is some good authority for the proposition they've got to go that next step and get the warrant. We have another search case, too. That's Her Majesty the Queen versus Clement, a decision of the Ontario Court of Appeal.
Yeah, you'll find that it's about the fifth case in your materials. And it deals primarily with the issue of consent. Consent, for a time, was a very useful tool with, in the hands of the police, because basically all they had to do was say, do you mind if I take a look here? And if, provided the accused didn't immediately stress some incredible objection, it was ruled to be a valid consent, and away they went. More recent cases, Wills, Borden, and Mellenthin, basically really tightened up the restrictions with respect to the availability of that exception to the warrant requirement. And basically those cases seem to hold that any consent has to be voluntary, it has to be unequivocal, and it has to be informed. And what informed means in these circumstances is a couple of things. The accused has to be aware of the potential consequences of giving consent, possibility of criminal charges, and the possibility that evidence obtained may be used against the accused. And secondly, aware of the existence of the right to refuse to consent, which place real restrictions on the availability of consent as a way of obtaining evidence by the police. And you can just try and imagine, well, how would the Crown, given that this is a warrantless exception, how would the Crown be able to establish these conditions? And short of either an admission on the part of the accused that he or she knew of the consequences and waived their right, or the police specifically advising the accused of these things in advance of conducting the search, it's difficult to imagine how the Crown could establish those preconditions. And I think Clement kind of shows you that continues to be the position of the Ontario Court of Appeal. For one, it was a case where the courts appeared to rely upon the fact that the accused did indeed make the admission during the course of giving evidence at the trial that yes, indeed, he did know, was aware that the police didn't have the right to simply conduct the search without a warrant, and seemed to be aware of his rights. So I think that falls into one of the situations where it may be valid, but it's certainly a very limited situation that the police can engage in.
And I say this, and it's not because the defense didn't succeed in it, but there's a very interesting and very thorough dissent by Mr. Justice Carthy, and he sets out the alternative line of approach in a number of important areas. Number one, the idea of what could be or couldn't be anticipated had the accused been advised of his right to counsel and the potential use that could be made of evidence obtained should he choose to consent to the search. And Mr. Justice Carthy considers the Supreme Court of Canada decisions and other decisions, he considers Mellenthin and a variety of other decisions, on the idea that we cannot say, well, guess at what might the advice have been or otherwise. In this particular case, he allows for the fact that the counsel may well have told the accused the police didn't have any basis to conduct the search, he didn't have any obligation to permit it, and it could well have led to the police not finding real evidence. And with respect to the concept of real evidence and whether it does or doesn't automatically go in, notwithstanding a potential breach of a right to counsel, there's a very good analysis by Mr. Justice Carthy there. The decision is worth going through in that regard. You'll see where he parts company. The majority says, well, the accused certainly knew that he had the opportunity to be able to refuse. He did consent. He was hoping that perhaps all they were looking for were drugs. That's the chance he took. He'll pay the penalty for it. Mr. Justice Carthy does a good detailed analysis. I don't know, Ken, is that case going to the Supreme Court of Canada?
I'm not aware of it. It may very well, because you've got a dissent.
Yeah,
but,
and we only have the decision July 14th of 1995. Read both parts of the case for that. Next ones we'll give you have to do with the area, what could be considered to be the area of remedies. It's always been of some interest. What if you have a measure of a breach of an individual's rights in some fashion? Can that ever have effect at the level of sentencing? And we have a couple of cases for you. One of them is the Ontario Court of Appeal decision in Glykis, G-L-Y-K-I-S, and Mangle, which is included. In that particular case, without going into the details of the breach, I think it was a right to counsel. It didn't connect in any way to the commission of the offense, and in those particular circumstances, it didn't have a relationship to the evidence gathering process. But the trial judge did find a breach, and he gave the accused some mitigation as a result on sentencing. That was the issue that went to the Court of Appeal. Under what circumstances can the breach of an individual's rights have some effect at the level of sentencing? And the answer the Court of Appeal gave is this. Number one, in that case, the breach did not mitigate the seriousness of the offense. And further, the breach was not in itself a form of punishment. So because of those reasons, the court felt that it was not an appropriate mitigating factor at the sentencing stage. And it wasn't enough to simply say, well, let's send a message to the law enforcement authorities not to breach someone's rights because it could have an effect on sentencing. The concept of a salutary effect for the police as a result of a breach at the sentencing stage was not accepted. By comparison, the court does give a couple of illustrations of what could be meant to be potential mitigating features when you have breaches. If you have a situation, for example, where the accused has been the subject of arbitrary detention for some 12 hours, or alternatively, references made to a case called Bosley, there was an unreasonable delay in the matter being tried, which was not of a sufficient length to merit a stay of proceedings, but could still be considered on sentencing. I would suggest the case is authority for the proposition. Each of those, the arbitrary detention period of time or the unreasonable delay, not enough for a stay, were, I think, considered by the court to be illustrative of punishment. Infringements which in and of themselves could have a measure of punishing effect and therefore were the proper subject for mitigation of sentence. Alternatively, they consider the pre-MAC days where the police could be engaged in some form of inveigling or entrapping conduct, perhaps not enough, though, for the level of entrapment. It used to be that that could be considered as a mitigating factor on sentencing, and the court considered that, by analogy, that had the effect of mitigating the seriousness of the offense, that the accused perhaps was doing it at the instigation or with the encouragement of police authorities. If, in fact, that encouragement took the form of a breach, then you could have an effect for mitigation of sentence. One other case we've given you is McPherson. Individual was held over a couple of days before he got to be taken before a justice of the peace. He was given some benefit on sentencing. You sometimes have it happen, perhaps. You can't find a JP available over the weekend. And so an individual has to be in for a couple of days because of the AG's policy on domestic violence. And then the accused gets out on the Crown consenting on the Monday because he's finally now before a JP who's prepared to conduct a bail hearing. Well, can that go for mitigation of sentence? The case of McPherson and the Queen may help you. And those within that reference to the Supreme Court of Canada decision in Simpson, 1995, one Supreme Court reports where actually proceedings were stayed, where an individual was not brought before a justice of the peace in a timely fashion. He was held over the weekend. So on sentencing, those cases are of some significance.
And I think the Court of Appeal has given its implicit approval to the approach taken in McPherson, because in the Glickus case itself, the court refers to an earlier case in Saskatchewan that had the same sort of situation where someone was a period of delay and it was suggested that there was some arbitrary detention. So I think that the approach taken in McPherson is the same type that was recognized by the Court of Appeal in Obert, or at least in Glickus.
Yeah, it's the best recognition we have so far by the Court of Appeal, the clearest, most unequivocal, that there can well be cases where breaches can lead to mitigation of sentence. These cases are all, by the way, available outside. So we've walked you through them. You'll be able to get them outside if you haven't yet picked them up. We got one more to do.
The only other case that we're going to talk to you just briefly about is McCarthy, and it's, I think, the last case in the materials that were handed out. It's not especially important for any particular reason, apart from that I think it shows that trial judges can make whatever findings of fact they want with respect to issues of credibility and resolve charter issues in that way. It's the McCarthy case was kind of interesting factually just because of the way in which it was litigated. There was a voir dire with respect to the reasonableness of the search, and basically what happens is the accused is called. gives evidence with respect to what clearly, if it was accepted, would have been an unreasonable search. He spoke of being handcuffed to a chair, being taunted with racial epithets, being hit across the head with something, shot with a toy dart, all sorts of abuse during the course of this search. The Crown basically doesn't cross-examine the accused, then calls, as part of its case on this voir dire, an officer who was there but was not the person that was alleged to be involved in this abuse. The Crown asks one question, whether they saw any police officer actually strike the accused. The police officer says no. Defense counsel doesn't cross-examine this witness, and that's the way it's left to the trial judge. And the trial judge, at least arguably, seems to say, well, I'm not prepared to accept the evidence he accused, and doesn't find that the search was unreasonable. And basically what happens is the Court of Appeal says it's up to the trial judge to make those kinds of determinations, and notwithstanding the fact that really there wasn't any contradictory evidence led in the way the parties litigated this particular voir dire, it was up to the trial judge to make up his or her own mind with respect to how to resolve that particular issue.
So even with a limited body of evidence, the trial judge made that decision, and certainly you'll see the Court of Appeals as well. It's before him. Mr. Justice Carthy, bless his heart, dissents on this one and says, really, there wasn't a proper consideration of the issues here. And one of the features that he picks up on, and the reason I mentioned the dissent, is something that sometimes happens by trial judges in ruling on charter issues. The trial judge said this. He said, with regard to the allegations of physical abuse and threats, that's a matter of credibility. At this time, I'm not prepared to find that the evidence of the police officer should be any less trustworthy than that of the accused. Here's the key. And that is a matter that may be dealt with more specifically in terms of the evidence as a whole during the course of the trial. And he anticipated that battleground would be fought again. After he let the evidence in, he thought there'd be a further battleground in the course of the trial, and there wasn't. We have to be vigilant to ensure that it's at the timing of the voir dire stage that the judge has to be able to make that decision, and it isn't something to be deferred until the end of the trial. It has to be decided now. And that's something Mr. Justice Carthy says specifically. That the judge may have blended or blurred the idea of a matter that had to be decided on the evidence at that stage, on the issues on that voir dire, and not wait and figure that it can all be resolved later in the course of the trial. We have to look out and ensure trial judges don't make a similar sort of error. Thank you all for attending. Ken, it's always been a pleasure working with you, and was again.
Thank you.
We'll see you again perhaps in 2 years, if not before. Please complete the evaluation forms. We'd like to be able to see and learn from them what has worked, what hasn't. We'd ask you to just take a minute or two and do that, and thanks for coming out.
Thank you.
Indeed, a pleasure. I think it was better than